New York Times vs. Sullivan is a Supreme Court case that happened in 1964 about the First Amendment. It started because of an article published by the New York Times called Heed the Rising Voices, an article that highlights the negative things the city of Montgomery did during the Civil Rights Movement. They ridiculed the Montgomery Police Department. The Montgomery Police Commissioner L.B. Sullivan got offended by the article because there were several things written in the article that were false. He took it as an attack on his reputation, even though the article never directly mentioned him. So he sued New York Times for libel. Libel being something written to ruin or damage someone's good reputation. Sullivan won at the lower court. The judge told New York Times that they owed Sullivan $500,000, $5 million today. New York Times did not want to lose, so they brought the case up to the Supreme Court. The reason it went all the way to the Supreme Court is because of the First Amendment and how much freedom it gave to everyone and how much protection it gives. Some things that happened before the New York Times vs. Sullivan case are Debs vs. United States. Debs vs. the United States is about the Sedition Act and how it's unconstitutional and goes against the First Amendment. The Sedition Act puts anyone who criticizes the war, World War I, or the President, Woodrow Wilson, in prison. It is the complete opposite of free speech. Debs made a speech about World War I but never directly mentioned the war or president and still got sent to prison. He sued and lost. The other event that happened was Shank vs. the United States. Shank vs. the United States started because Shank posted an article that opposed the World War I war draft. He got arrested for breaking the Espionage Act. The Espionage Act would arrest anyone who made the people in the military disobey order and intervene with the draft or military recruitment. Shank said the First Amendment protected him, but he was still in prison because of the Espionage Act. He brought the case to the Supreme Court, but lost. He could have won during the peaceful times, but he lost because it was war times, and his articles went against war efforts. The third event is Brandenburg vs. Ohio. Brandenburg vs. Ohio starts with a news channel airing a KKK rally and speech made by Brandenburg that seemed threatening. He got arrested for breaking the Ohio Criminal Syndicalism Act, an act that made it illegal to promote the use of violence to change political or social issues. Brandenburg said his speech was protected under the First and 14th Amendment. The lower courts dismissed his case, so he went up to the Supreme Court, where Brandenburg won 9-0. Brandenburg's speech was safe and protected by the First Amendment.
On March 9, 1964, the final decision was made by the Supreme Court. The Supreme Court issued a unanimous vote of 9-0, meaning they were all for New York Times. The court said the newspaper company had all rights to publish their statements under the protection of the First Amendment. The court said in order for Sullivan to prove that libel was used in the newspaper, Sullivan needed to provide evidence that was set against him to prove malice. Justice Brennan delivered the opinion of the court. The main question is whether the First Amendment allows a public official to bring defamation actions for false statements about public issues. Justice Brennan explained that public debates can express intense feelings such as sarcasm and express attacks and false information about the government and public officials. But the First Amendment allows any kind of speech to be expressed, including hateful and targeted opinions. But the court said if a public official can prove a false statement that intends malice, the public official does have the right to sue the person. Sullivan had to prove that the New York Times knew the statement was false, but he failed to do so. Brennan summarized that the New York Times didn't know that the advertisement had inaccuracies. This concludes that the New York Times did not act maliciously towards Sullivan and couldn't be held liable. Justice Black's concurrent opinion was the press was 100% protected by the First Amendment and they cannot be sued for defamation claims by public officials, but he thought the Constitution should protect the press from defamation claims by public officials if the press intended malice. Justice Goldberg also agreed with Black's opinion that the press was protected by the First Amendment.
People involved in presenting the case to the Supreme Court were L.B. Sullivan, who was the one to press charges on the New York Times and was Public Safety Commissioner of Montgomery, Alabama, petitioners and police personnel who testified, the New York Times, who was being charged for publishing false information, and Mr. Justice Brennan, who delivered the opinions of the court. The New York Times versus Sullivan case is significant because it made an important impact on what a news outlet can or cannot share if it is not true, and if they can be punished for spreading false information. The New York Times took creative liberties with an ad campaign and tried to disseminate false information about how the police reacted to the civil rights movement protest and made it sound as if the police were trying to harm the petitioners, and that they imprisoned Dr. Luther King Jr. 7 times even though it was only 4. The final verdict of the case was in favor of the New York Times, because there was no proof of malice. Even though what the New York Times did was wrong morally, doesn't actually mean they can be punished or held accountable for their actions if there was no malice in their intentions. Even today, this topic of what news outlets can or cannot share if it is not true is still debatable. If there is no proof of malice, like in this case, technically the news outlet didn't break any law or do something illegally because they have the right of freedom of speech. Even though the New York Times won the case, it brought up an important issue about spreading false information and how if there is no malice or ill intent, it is not punishable by law. This case helped determine how and if a news outlet can be punished for spreading false information, but also not restricting their right to freedom of speech.
On March 29, 1960, the New York Times published a full-page ad titled "Heed Their Rising Voices." The advertisement became the source of a libel suit in the United States Supreme Court case, New York Times v. Sullivan. On February 25, 1964, in the basement of the Montgomery Country Courthouse, students from an all-black academy, Alabama State College, sought service in a snack bar. These students were rebuffed, arrested, and expelled the following day due to the ex officio chairman, Governor John Patterson. 2 days later, the state capitol was marched by almost 800 students at Alabama State College who were intending to protest Patterson's actions. During these protests, the Montgomery police stood by while bat-wielding members of the Ku Klux Klan assaulted said students. This attack went unpublished even though the Montgomery Advertiser ran several pictures of the incident with several members of the mob clearly evident. Later, a group including A. Philip Randolph and Bayard Rustin, who were veteran civil rights activists, determined to take out a full-page ad in the New York Times that would not only condemn the violence in Montgomery, but also raise funds for the larger cause of civil rights. In an attempt to make the ad hard-hitting, Randolph successfully pushed Rustin to add the name of prominent endorsers, comforting him with the lie that they had all been involved in the movement and lent their names previously. This caused many issues to arise because, for one, the Times department, who were in charge of checking the accuracy for these articles, signed off on it without question. The ad was directed at white, progressive, intellectual leaders in North America, one in particular named Merton Roland Nachman. Nachman, the foremost liberal lawyer in Montgomery, brought the ad to the attention of the 3 city commissioners as well as notifying the police commissioner, L.B. Sullivan. Nachman confirmed to Sullivan that there was no doubt the police commissioner could bring action against the Times, for the ad had cast aspersions on Sullivan regarding the implication that the police force was complicit in the bombing of the home of Martin Luther King Jr., and more generally that it condoned acts of terrorism. The city commissioners were easily convinced, and Nachman began proceedings on their behalf in state court. New York Times v. Sullivan brought a civil libel action against New York Times Co. after it printed allegedly false and defamatory statements about Sullivan's actions to control African American protesters and his treatment of Dr. Martin Luther King Jr. This case brought attention to the First Amendment of the United States Constitution. The First Amendment prevents the government from making laws that regulate an establishment of religion, prohibit the free exercise of religion, abridge the freedom of speech, the freedom of press, the freedom of assembly, and the right to petition the government for redress or grievances. Obviously, New York Times v. Sullivan had many problems regarding the First Amendment, problems which included the freedom of press and the freedom of assembly.